Good morning, everybody. We are waiting for the verdict now. Um, so, good morning, Matthew. Good morning, Gina, Forum, Jody, and Wendy. Hope you guys are all doing well. So, guys, I have things I need to do, so I'll be kind of popping in and out and sitting here. But yeah, for right now, I gotta take care of some things, and I'll be right back in a couple of minutes. But I will be up, and we'll leave this thing going for a while. At least all day today till they're done. I will put up a poll though, because I am curious to what you guys think. I think there will be a verdict by lunch, at least noon by Eastern Standard Time. That's what I'm thinking. So let's take a look and see if anybody agrees. We'll call hello, Luke. Hello. Let's see here. Well, Matthew, I guess I'll break it to you. You're gonna be a little disappointed then last night. So there's gonna be a spot though partway through. You're gonna turn your sound down. I forget when, but you'll figure it out. But the lights are off. I wonder if they're not actually there yet. I mean, they said they wanted to start at 8:30, but the lights are off, and nobody's there yet. So kind of like what the F gives. Little bit of a problem there. I think just a little bit, just a little bit. Right there, right there. So yeah, I don't know what that means. Why there's not everything's lit up. So do. So yeah, the judge said 8:30 if I remember 100% correctly. Matthew, no mutes. You need to see the evidence and watch it. Hey, you got all the evidence for you, brother. Um, oh, Melvin. Melvin's got a prediction here. Verdict after lunch. Jurors don't need to return to work to get paid today if they work past lunch, based on my personal experience. Well, it's not necessarily like by law they have to go back to work, but yeah, I'm sure that they're all looking forward to can I just get out of here early? And that's got to be on their minds a little bit. I think it'd be a lie to say that isn't, but they also might say no. We're all about getting this done right. and they might be here for the long haul. Do I think it'll happen today, though? Yes. I think it'll happen by lunch, but it could also happen afterwards. Pearson said also it's Friday. Yep. You have to quote the great Rebecca Black. It's Friday. It's Friday. It's Friday. It's Friday. Depends on how good the lunches are here. Well, I don't know. I mean, there's a lot of good food down in Delaware. There are a lot of good restaurants. It's a nice little town. It's nice and clean and pretty. Like they got a bunch of cool stuff there. Good places to eat, and I say that as a professional fat guy. Um, so they probably have something good on the menu for them, but I don't think this goes past. We don't. We don't. I don't think there'll be extra days of deliberation. This will be it. Then I wonder if they would have them do on Saturday, or if the jury would come back Saturday. That'd be interesting too. Um, let's just see one more time where everybody's at with their stuff. All right. I am, like I said, I'll be back in a little bit, guys. We're going to just kind of ease on into this. So, Matthew, you're asking, like, could they work tomorrow? I mean, it's up to them, but I mean, the judge could also decide I'm not opening the courthouse. It's also not his courthouse, and there's no sequestration. The jury's not sequestered, so time is not of the essence. They might just wait till Monday to come back and deliberate. It could easily be that, and actually, good chance that would be the case. Is Monday they would just come back and deliberate. Um, so probably they would just come back Monday. I don't think they would come back Saturday. I was just throwing it out there. If they really wanted to, I could see it happening, but I doubt it. These people probably want to enjoy their weekend. Yeah, but next, the week after Monday is our Labor Day here in America, so that's coming up. Yeah, the one juror claims he was harassed, but I mean, it probably wasn't enough of harassment that the deputy got involved to get people's information. So, was it really harassment? I don't know. Not sure. We shall see. Oh, okay, the jury's officially in. The jury's officially in there now. They're working. Nothing like 13 minutes late. That's too good not to leave up on the screen for a bit, Melvin. Bravo. Bravo. Hey guys, I'm back. Sorry. David Davidson saying yellow is question, green is verdict. Yes. D&D, yeah, the light will change to either yellow or green. Night 107, he's saying it's probably an empty room in the sense, yeah, that's an empty courtroom, and if nobody's making any movement, the lights are going to go off. So the judge is in his chambers, everybody else is doing their thing. The prosecutors are at the prosecutor's office. Diane and the defense team are somewhere nearby. The judge said stay within the county. So she's probably nearby. She might be hanging out with Matthew still. I don't know. Matthew's probably he's probably sitting in civilian or his jail uniform. They probably don't have him sitting in his street clothes right now. So yeah, everybody's just waiting. It moved. Ooh, Matt's just saying it moved. Kind of hot. But anyways, good morning, everybody. Hope everybody's doing well. Yeah, I have to run another errand, but I am working from home today, so I will be back on screen probably in another half hour or so, I think. I did put a poll up. Let me know what you guys think is going to happen. I think we'll have a verdict by lunch, which is noon Eastern. So let's see what happens. At the very least, it's going to happen today, I think. I don't think it's going to go much longer. As far as guilty, not guilty, we'll get to that once we know there's a verdict on the way. But I hope you guys are all doing well, and I hope you guys can hear me. Actually, let me know. Can you guys hear me? Also, guys, no, we can't hear you at all. Thanks, guys. If you guys have any questions in the meantime, don't be afraid to throw them up. I'll answer them as we go. Yeah, I don't know about the status of the kidnapping case. I mean, we can check in on it, but Summers wanted to cross-examine his wife, and I think that was the primary reason. Up until that point, his standby counsel was performing the job, and then he took over. The problem is, once you do that, you can't go back. You're not allowed to do that, switch back and forth. Once you make the decision, you're stuck. So I think he's going from there on out, but I assume he's going down in flames because he wasn't doing the best when he cross-examined his wife. Yeah, well, guys who rape and kidnap their wives tend to be that way. Sweet tooth. Um, just saying, that kind of goes without saying. All right, guys. Sorry about that. Guess I got back right in time. Unloading the car. We have a verdict. Excited. Let's do a poll. All right, guys. Here we are. Wow, long crime is even on our side now. So let's see, everybody. I'm a little Court TV's 5248. Oof. The sound is controlled by Long Cuck. Shizzle, can Mathew file wrongful imprisonment against the state if he's found not guilty? No. No. I mean, they had probable cause, and that's going to be enough. This wasn't a malicious, prosecution either. So, Night 107 is saying, I'm still waiting for the meat of the state's case. Will we get that today? Yeah. Yes. I am surprised it came this early. I think everybody looked out the window and thought this is a great way to end the weekend. So, oh look, there's prosecutor Poopy Pants. He's sitting there. I wonder if they lose, is he going to scream, "This is a sham! This is outrageous!" He's going to walk out on the jury. So here we go. Sean is here, or was. I'm still here. I'm down on the bottom. I'm still here, guys. Melvin, Matt's chance is to sue the state experts for negligence. There's no indictment without the anthropologist and expert reports. No, those reports were still being generated as the case was going on. So, no, he was going to get indicted anyway. Can they convict on a lesser charge? No, they were not given a lesser charge to convict on. The jury instructions in the charging forms were just for murder and felonious assault. So no, they can only charge on those things. Good question though, Dustin. Very good question. Because normally, yes, there is always a lesser charge, but no, that didn't happen here. Shizzle. So basically, you got to take it on the chin if the state brings charges. Yeah. Sorry, but that's the reality of it. Hillary, how you doing? Welcome back. Thank you. Yeah, was out running that errand and I got it done in time. Couldn't get my sound to work in the car, but yes, I saw the lights and I was hauling in. So maybe I did run a stop sign or two to get here. Rolled through them. I imagine the assault, but not the murder. Well, even if he gets even that alone, that's 2 to 8 years in prison. There'd be a presumption for prison on that. So, there's a very good likelihood we go to prison for that. Most likely he would go to prison for that. So, hang tight. Let me. Somebody also mentioned he didn't get a lick of sleep last night. Oh, I bet he did not. Could you? I don't think I would. Let me grab. I gotta close the store, guys. Hold on. I better change the I'll put out a community post. Do 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 do. Sound is all the way up, guys. I just double checked. We are waiting on the verdict. We'll see very quickly. Now it looks like we're waiting on the judge, if I had to guess at this point. If I had to guess, we're waiting on the judge. So let's see here. Need to fix something. Um, YouTube, why do you make this so it's not advertiser friendly? I'm just covering a murder trial. Jeez, I didn't murder anybody. And there's no bodies or anything on screen. This is just ridiculous. Pedantic bastard, yes. When will they convict this dangerous mastermind who leaves no evidence behind? Yes. Okay. So all those people behind the prosecuting table, that's probably the whole office. It's Friday. You usually don't have a ton of hearings on Friday, even as a prosecutor. So yeah, that's a bunch of the offices here now. That's probably a bunch of the office staff. Because let's go through it. That guy's the prosecutor. She's the prosecuting attorney. He's obviously, bitch boy. Obviously detective. But then these guys are all prosecutors back here, if I had to guess, and office staff. So And those people behind Mathew, I don't know who they are. They could be, onlookers from the court, one of a reporter or two, maybe somebody, friend, family, who knows. He looks like he's praying. Yeah, he's not praying. That's probably his pensive, like waiting posture. Firefly. Well, I don't know what else to call him because it was a bitch move. It was a biatch move. I know you guys calling the prosecutor Jen Psaki. Jen Psaki's got far bigger boobs, so don't use that. There's Mathew. I mean, I think he's kind of like nervous, but I mean, he's at peace. It's like it's done. Nothing else to do except read it. It's not going to change in the meantime. I mean, imagine what's going through his head. I mean, for having been in this situation, it is very. Well, I gotta close one of my blackout curtains. It's a little bright in here. There. It's a little dark. It's a little dark, but yeah, having been in this position, it's weird waiting for verdicts. It's weird. Parallax, what did I just stab with a sword? I had to move. I have blackout curtains so I could do stuff during the day. Because early on, if you watch some of my early videos, like early trial streams or things I recorded during the day, the blinds I have up don't really block the sun, and I kind of got washed out by the light. So I got some blackout curtains that help with that. So by Francis, all the best lawyers have swords in grabbing distance. Yeah, I also have guns in grabbing distance too. 65 people watch it, guys. Please like and please give me a like. In the meantime, if you like what you see here, if you really like it, give me a subscribe. I do stuff all the time. Um, and I would appreciate it. So let's see here. Yes, Matt, I'm reading your comments. Thank you. With friends like this. With friends like this. um Oh, while we're waiting, I guess I can show um Josh said, "What was the tantrum yesterday by the prosecution?" Oh, then we could show that real quick. Let me pull it up. Um, yeah, we'll watch this real quick because we do have some pee pants going on, and I have the sound going in the background. Um, Have I covered a case from Ohio where it wasn't a complete piece of shit? Yes. Audra, what's her name? Crap, now I gotta look. Way back when. Let me see here. A shitty one would have been Audrey Cole. I covered day 2. It does enough to catch you up on what happened. That was an interesting one. It wasn't a shit case. It's just the jury didn't buy. They bought her self-defense argument. So I did that way back. So I apologize for the quality. Lawyers always got interesting things in their offices. Well, this is like my home office, more like a studio. So it's not really people come into this one. My other office is pretty boring. Pretty boring. Yep, his name is Mark Slepper. So, Patty F, good morning. Thanks for stopping by. So, even then they still lost. Yeah, but it's a lot better case. It's a lot closer of a call. But as somebody wanted to ask, we will show the video. I think this will work now. If this, let me know if you guys can hear this.
Sorry, but I would object to going forward anyway right now without the elected county prosecutor who's on this case.
But she chose not to be here.
That's not accurate, Judge.
Can you guys hear that at all?
Okay, okay, your objection's noted.
We had a phone status conference 2 weeks ago in which Ms. Schiffel...
Your objection is noted. Okay?
Oh, so we did. I figured out how to do this without being a boomer. Okay, so this is the judge. This happened first thing yesterday morning. So we'll start over.
Sorry, but I would object to going forward anyway right now without the elected county prosecutor who's on this case.
But she chose not to be here.
That's not accurate, Judge.
Okay, okay, your objection's noted.
We had a phone status conference 2 weeks ago in which Ms. Schiffel...
Your objection is noted. Okay?
I'm not going to participate in this proceeding without the elected county prosecutor. I think this is a sham that you're going forward. When the court was
You're going to sit here. You're going to sit here.
You were told about her unavailability and specifically told her on the phone not to cancel that appointment, that it wouldn't be a problem.
Well, I'll tell you what. If you want to be here for the decision, that's your business.
Well, Your Honor, I think this is outrageous. You're going forward without the prosecutor.
It's outrageous. Oh, I'm big and strong. Look at me open the doors. Oh.
I have prepared my remarks and my decision here today.
Oh.
Wait, what the fuck? He just walked out like that? What the fuck?
Yeah, apparently that was recorded from yesterday. But yes, that was my reaction. It was like, are you fucking serious? Like, you can't do that, man. You can't do that. That is not allowed.
Whoa.
And my decision here today.
Ooh.
Yep. Oh, what? No, okay, sorry. Sorry, guys, I messed up. They're still not going. Share screen. Sure. All right, we're back to the cuckings. But yes, that was Mr. Girlfriend running it from behind the camera. That would explain the lack of mutes. No, I'm just on it today. And also, I guess while we're talking about funny stuff, Stabby sent this to me in Discord. We may as well watch this for a second. This was from I guess some of the people in chats involved with Ricada, but this is from when I was down in Virginia. I attended my grandmother's memorial service, and this was right in the middle of the Johnny Depp trial. And it was on a Saturday, so we stopped by the courthouse and ran into everything that was out there. Yeah, very well done. Bravo. Bravo, Stabby. Yeah. Also, by the way, it was like 100 degrees in that picture. It was awful outside, and I was only outside for like a minute. And my girlfriend's taking the picture. She leaned over to take it for me, and I was just like, "Oh, yeah, look, here's some of the competition." Helped brought in more views than Core TV did. Yeah, how do you like that? Guerrilla journalist. Um. All right, but let's get back to the thing we're here for. What we're here for. Let's get back to the money shots. No, they also might be giving the jury a chance to take a break. I don't know. But everybody else is here ready to go. Usually it's you're waiting on the defendant and everybody else. So Diane's co-counsel is not there today. I don't see her. Unless she's hiding on the other side, but she doesn't need to be here. Maybe she's doing office work. You know, look at the prosecutor. He's just thinking, "Oh my gosh, everybody thinks I'm a loser. Oh no." Plot twist: is this the actual Matt? This is the actual Matt from Tinder. Maybe. Oh, everybody's saying she was here earlier. Okay, good. Good on her. Good on her. Somebody's saying, is the guy in the blue shirt my brother? He's my brother? I have a brother? Brother. Help me, brother. I am pinned. I don't see this guy. So let's look. Where is this guy? I want to see him. I think I see the edge of him right there. I know this has been asked 1,000 times, but what are the movies The Art on Your Wall from? Okay, we'll do this again. Okay, we'll go big screen for a moment. Yeah, the dark blue one. Oh, okay. I mean, are you guys just saying that because we're both fat or what? Because I'm a little offended by that. You know, we have feelings too. We just tend to eat them a lot. So, okay, Parallax, you wanted to know. Okay. And it's easier to do it this way because then I can see what I'm aiming at. This right here is Hunt for Red October. And then this here is Heat with Robert De Niro and Al Pacino. And no, when I say Heat, it's not a gay porn or anything like that. Heat. It's a movie. Got Val Kilmer, Tom Sizemore, Jeremy Piven, Natalie Portman in it, John Voight. It's got all kinds of good people in it. So his beard looks pretty similar too. Oh, I don't know. We'll take a look when we see him. Oh, here we go. It's game time, folks. Okay, that guy is not my twin. I get it, though. Actually, okay, yes, he could be my twin. Fair enough. You win this one, chat. All right, let's fucking go, kids. Let's go. Drum roll time. Sound of Diane slowly coming up from behind and murdering the prosecutor's case. Very true. Bye, Franz.
Thank you. Have a seat. Good morning. Have you selected a foreperson? Juror number 2. Have you reached your verdict, sir? All right. Would you please hand them to...
Geez, did the judge just run in or something? Like we interrupted his marathon training, or he ran all the way here.
Thank you.
Okay, I'm all right, guys. Positive vibes here. He needs them. Good vibes. Good vibes.
The court will now announce the verdicts. Verdict on count 1. We, the jury, being duly impaneled and sworn, find the defendant Matheau L. Moore not guilty
Yes!
of murder as he stands charged in count 1 of
Booyah!
the indictment dated the 26th of August, 2022, signed by all 12 members of the panel. Verdict on count 2. We, the jury, being duly impaneled and sworn, find the defendant Matheau L. Moore not guilty of murder as he
Boom,
stands charged
son!
in count
That's
2 of the
right!
indictment.
That's how you do it,
dated,
Matt.
26 August 2022, and signed in ink by all 12 members of the panel. Verdict on count 3. We, the jury, being duly impaneled and sworn, find the defendant Matheau Moore not guilty of
That's
felonious
how it's done,
assault as he
baby.
stands
That's
charged
how
in
it's
count 3 of
done.
the indictment
Fucking stack
dated,
those dubs.
August 26, 2022, signed by all 12 members of the panel.
That's right, Diane. Get it,
Ladies
girl.
and gentlemen.
Get it,
I
girl.
cannot
Get it,
personally
girl.
enough express my appreciation for the time and the attention you have given to this court during the course of this trial. This is one of the longer trials.
Long
that
Cook must be fucking melted
occur,
down.
And you all were willing to give your time and absolute attention to this matter. And you certainly received the thanks not only of this court, but the community as well for your service. As I said earlier, and I believe it again,
This is a
your
shield.
participation has strengthened and fully served our institution of justice in this county and everywhere else for that matter. So we have now concluded your service to the court in this matter. I will, now I guess number one, I'm going to share with you, you are released from your admonition. So now you may speak to anyone
Wow.
that you wish about this matter. You may review anything that's been going on. It's entirely
We'll talk
your
about this.
prerogative. I will now discharge you, and you can go back to the jury room. I will tell you that I would like to go back and speak to you privately if you're willing to do that. In other words, if you wish to leave, you're certainly entitled to do that. If you'd like to go back, when I concluded my business here, I'll briefly go back and speak to you, share some moments with you, and then certainly you can go on your way. So it's up to you, but I'll have you go back to your jury room now, and we'll proceed with a few things in here. and then I'll go back to the
100%,
court.
Bren.
Thank you.
Oh, I bet they're melting down. You'll hear the rees from Canada. Yeah, just like, thanks, guys. Thanks for not putting me in jail forever. Man, I'd be mailing, like, every Christmas, I'd mail the fucking prosecutor's office a box of fucking USB cables if I was him. I would be such a fucking asshole if I was Matheau Moore. Just a fucking dick.
Mr. Moore, I think from day one, everyone's wanted justice for your wife, Emily. And I've heard that phrase a lot, and I think everyone truly desires that. But I think the jury has also said justice for Emily is not injustice for you. And they reaffirmed that. I will just formally say I am terminating the bond previously set in this case, and you will be discharged and you are free to go. We'll do that. We have an entry that we'll prepare immediately to cause that to happen. All right. Anything else from the state?
No, Your Honor.
Anything else from council?
No, Your Honor.
I'm going to ask them if they would be willing to speak to council. That's really one of the main things I'm going to be doing. So if any of you would like to do that, I will come back out here and let them know, and then you can go speak to them if you wish. Thank you for your service in this case. Yeah, you did a fine job, and same with you folks. So we are in recess. We will file the verdicts with the clerk. We'll proceed from there. Thank you.
I kind of get the feeling the judge is going to acquit this if the jury didn't come back with the verdict. He seems to have been very, like pointing out this case was shit. Yeah. Hey, anyways, Oh wait, I'm surprised. Are they gonna say? Is the state gonna go? This is a Sam. This was a. Oh whoa! This was so bad. Are they gonna fucking pussy their way out again? They gonna give a press conference? No, look at them. Did they just walk out? Yeah. Wow. They're so mean. They're so bad. Woo 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 woo. Go look at Long Cuck's chat. Oh my god. Oh my god, there's so much cope. That is so much cope. Copenhagen. Cope. Oh, look. Hey, my twin's about to message me. Maybe he's like watching like some horse porn or something. A lot of people are crying. So guys, what's going to happen? Somebody actually asked us that. I wanted to answer it. So we can leave for the courtroom. No, they're going to take him back to the jail. He's not going to be handcuffed anymore. He's free to go. He has to get discharged officially from the jail. They have to unbook him. So they have to release him. There's release procedures. Obviously, though, he's never going to be cuffed anymore. He doesn't have to be. He's an innocent man. But he gets a discharge, so they got to give him all his shit. If he's got commissary money, they pay that out. All kinds of things, and then he gets to walk out the door of the Delaware County Jail. Monad saying, "Can you imagine Diane versus Camille? That'd be hard to watch." As savage as Camille is, there's a level of like savagery and gunfighting that you only get in a criminal trial. Yeah, Camille can play when there's money on the line, but can she play when it's life on the line? Now, I think Camille probably has got the balls and the skills to do it, but I wouldn't want to see Camille in her first time deal with Diane. She would need some time. Yeah, the savagery of sending an Xmas gift to the prosecutor. Yeah, just send him USB cords. Like, hey, maybe it's this one. Maybe it's this one. Oh my gosh, there is so much. Although there's a lot of people in there who are like totally cool with it, which I'm surprised. I'll leave that one alone. It better be a fast release. Oh, it will be. They, especially in this type of situation, they are not going to fuck around. And Diane went back with him. If you notice that, she went in the back with him. So that's going to be quick. And if they fuck around with that, all Diane has to do is call the court and say they're not doing it fast. KTB, yes, they have announced it. Not guilty, all counts. Not guilty, all counts. Diane's walking out the court, throwing up them fucking dubs, man. That's all she does. I mean, damn, she's having a pretty good year. Oh, they'd be on the same team. Yeah, that would be an impressive team, I think. Diane is Camille with 20 years more experience. I don't know exactly, but probably close. But also Diane is Camille, but imagine Camille being a gunfighter. Lacey P with a super chat. Thank you so much for your super chat. I appreciate the support. For $19.99. Thank you for covering this case. Can't wait for the next trial. Well, neither can I. Yeah. It'll be great. Thank you again. I appreciate it. Matthew, I've been trying to work on that a little bit, and I understand why she's probably a little busy, but I would love to get that from I'd love to do that. Oh, yeah, long crime now. He fooled everybody. I don't think he did. Yeah, but no, that's where we are, guys. Good news today. How much trouble will we get in if we mail the prosecutor USBs? I'd be careful about doing it, but certainly you could like Amazon Prime them something just to fuck with them. I mean, I would never encourage that. Do not do that. If you do that, make sure it's of your own decision. You don't want it to seem like you're harassing them or intimidating them. So that's all I can tell you. So I can't encourage you to do certain activities. I would say refrain against them, but obviously you are a grown adult and you can do as you wish, Patty. But I don't necessarily think you would get in trouble. If you just, that like as long as there's nothing threatening or menacing in there, that would be fine. But like I said, I cannot condone such or encourage such activity. Arash, thanks for stopping by. Good to see you again. Very nice dark blue shirt today. Well, thank you very much. Mail them toes, you pussy. Mail them toes. They might not even get that joke, so I don't know how well that would work. I don't know how well that would work. So, let's see here. Boop, boop, boop. Damn, what did I cancel out of? Wrong thing here. Prosecutors got a print too. Just a question, LOL. No, I get it. And if you sent them something, just make sure it's not menacing or threatening. But, if you put something in there like LOL, better luck next time, and you sent them a black cord, I mean, you're allowed to mock elected officials. So you can send them mocking things. I just can't encourage you guys to do it because that would just be me harassing other attorneys. But if you were to do it, nothing would stop you. And there would be nothing illegal about it, Patty. So if you did it, you'd be fine. But yeah, guys, justice. I think justice was done today. Whether or not he surely did it or truly did it, I don't know. I don't think he did necessarily, but he could have. But remember, that's not the standard of, well, could he have done it? Because it's, did he do it? And yeah, I don't think they definitely did not prove that. That was just awful. I mean, they ran with what they got. I mean, yes, the prosecutors did the case they had, but that was not a good case. Branca and Ricada are still planning to bring Branca's books to the DA's office in Kenosha, and that's fine. Remember, what you have to do though is they both are not licensed in Wisconsin, so it's a little different. That's also just clearly done in jest and clearly meant to mock them. So as long as you guys do it, if you were to do it, like I said, I just can't encourage it. I can't encourage it, but if you guys do it, then make sure you do it. It's respectful. And I mean, in the sense of if you're going to make fun of somebody, sorry, I got a little thing on the screen I was trying to clean off. If you do it, make sure you don't do anything menacing or threatening, or it could be interpreted that way. So that's what I would say. Just if you're going to do it, don't do anything illegal. Don't threaten anyone. Don't threaten actions. Don't be. You can be a smartass. You just can't be a criminal smartass. So that would be my only thoughts. So that would be my only thing. So if you guys want to do it, that's, like I said, as long as you do nothing illegal, you are allowed to mock your elected officials and they cannot seek reprisal against you. Especially if you live in another state. I mean, that would just look really goofy on their part. Do I have time to go to Summers? Yes. The sex boys are here to party. Yeah, maybe the press interview Diane outside the courthouse. Yeah, I'm looking for looking to see if there's any press conferences or anything. Yeah. So we'll flip over. Oh, Trevor Summers declined to testify in his own defense. Apparently this just came up. He rested his case just now. Yeah, we'll go into that one. We'll go into that one because it looks like it's going. Let's see here. Let's see here. Law and Cuck. Yeah, we're gonna go back and start watching this here. All right, guys, we're gonna jump around and get it. Mike and Kurt have been watching it this morning. Oh, well. Yes, he cross-examined his wife during the case. That's when he took over, so he could do it. So, let's get that up here. We'll go back and we'll kind of rewatch some of it because that'll probably be a little easier to do. So we're gonna have to skip around for a minute, so bear with me, guys.
But Mr. Summers, I gave you the evening to consider your decision whether to testify or not testify. We're going to get to that in a moment. And we have some time because one of our jurors, I just want to let you know that number 7 is not here yet. That's the same gentleman that was late yesterday. But it's all right. We'll see. We'll address that as that'll be the last thing we address, and maybe he'll be here. The traffic was terrible. It took me twice as long to get here this morning. So I suspect that the traffic is probably the reason for that. But the first thing that I want to address this morning is that I was advised by the clerk's office this morning that for approximately 1 hour last night, the evidence was left in the main clerk's office before it was ultimately moved to the evidence vault. The clerk's office, though, this morning has gone through all of the items of evidence with the list and has verified that all of the admitted evidence is, in fact, accounted for. So I just wanted, since they notified me of that, I wanted to notify you all of that same information. All right? All right? All right. So that takes care of that. The jurors here, which is great. So things are starting to fall into place. So now, Mr. Summers, I am going to turn to you and address you and your decision whether to testify or not. The first question, actually, I do have to swear you in if you'll raise your right hand because I have to ask you a number of questions. Thank you. Do you swear or affirm any testimony that you may give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
All right, thank you, sir. The first question that I want to ask you is, did you have the opportunity to consult with standby counsel regarding your decision to testify or not testify in your case?
Yes, Your Honor.
Do you understand that you have the absolute right to remain silent and not testify in your case? The other side of that is, if you wish, you can come down and testify as a witness, just as all the other witnesses have testified. I think I mentioned the procedure to you yesterday. I will follow the same procedure as all the other witnesses. You'll come in front of me. I'll swear you in. You'll take the stand. The only difference is, since you're representing yourself, you won't have someone else to ask you questions. So your testimony will be presented in a narrative form where you can just talk to the jury. If at any time you are presenting testimony that the state believes is objectionable, they would then object, give me the legal basis for the objection, and I would make a decision as to whether you can continue saying that. The issues that may come up are relevance, hearsay, things like that. So much like the things that have come up with other witnesses. At the end of the day, it is your decision and your decision alone whether you are going to testify or not. My next question to you, sir, is have you had sufficient time to consider this very important decision?
Yes, I have, Your Honor.
Have you made a decision?
Yes, Your Honor.
What is your decision?
I will not testify in this.
Has anyone forced you or threatened you in any way to reach this decision not to testify?
No, Your Honor.
Are you under the influence today of any alcohol, drugs, medication, prescription, or over-the-counter that may in any way affect your ability to freely and voluntarily make this decision?
No, Your Honor.
Okay, thank you. I appreciate. Let me just see. State, did you have anything else that you want me to ask him regarding his decision?
No, Your Honor.
All right, thank you. Thank you very much, Mr. Summers. So that means that you need to rest your case. Again, I can't help you and I'm not helping you, but some of the procedural things that you may not be aware of in order for us to move forward, I will let you know. That means that you have presented all of the evidence that you intend to present. Do you agree? Is that correct?
Yes, Your Honor.
All right. So that means that we're at the stage where you would rest your case. What I propose that we do, since all of the jurors are here, is that I bring them out. I turn to you. I welcome them. I ask them if they've been exposed to the case, just like I've done every other morning. I then turn to you and ask you or tell you you may proceed. And then it would be time to announce the resting of your case. Then once you've done that, I will tell them that there are legal matters, because we then have to go over the jury instructions, the charging conference that I mentioned, and I asked you to read the instructions last night. So I would then explain to them that now that, well, let me just make sure. I would then, once the defense rests, turn to the state, who has the opportunity, if they wish, to request a rebuttal case. Is there any such request?
No, Your Honor.
All right, excellent. So knowing that, what I may do once he rests, I'll turn to the state. Is there anything else from the state? And you can say nothing. And then I'll tell them now both sides have rested their case. I have to go over the legal instructions and legal matters with them. I don't know how long that's going to take, and send them out. I know that I don't know how long it's going to take, but I know it's not going to be super short. So I'll leave it up to the bailiffs if you want to let them go to the coffee shop or something like that and come back, since they're going to be in that room for a little bit of time. Is there any objection to that procedure?
No,
Just
Your
like when they take a lunch or anything like that, we'll tell them maybe an hour. It may not take that long, but I'd rather that we're done and waiting for them than they're back there waiting for us.
That's fine, Your Honor.
Do either of you think that an hour, I mean, I could say 40, let's do 45 minutes. We have to print, so we'll tell them 45 minutes. All right. So they can go for 45 minutes. All right. Is there anything else from the state before I bring them in?
Nothing from the state, Judge.
Mr. Summers, anything from the defense before I bring in the jury?
Not at this time, thank you.
All right. Let's get the jury. Thank you. And I'll try very hard not to say ladies and gentlemen and then correct myself. It's only, the fourth day. Good morning. How are you? God, it's cold in here today.
Not yet. It gets colder though.
It's really
Oh, fucking A. Okay. He is accused of attempting to murder his ex-wife and kidnap her. Fuck you guys. Fuck you. The way why he's on the side of the courtroom, generally the prosecutor sits in between the defendant and the jury. So it's whatever side the courtroom's on. So that's why. So we'll keep going.
really cold.
By the afternoon, it's freezing.
Yes, we are.
All rise, jury, in courtroom.
Jury is present and seated. Everyone else may be seated at this time. Gentlemen of the jury, good morning and welcome back. I know it's a little bit later than we had expected to bring you in. I do apologize for that. Take full responsibility. I also know that traffic was very bad this morning. I'm not responsible for that, but I was actually part of that myself in that traffic. But thank you all for being here and for being here safely. First thing that I need to ask you is whether any of you, by raising your hand and letting me know, were exposed to anything about this case outside of the courtroom between the time you left yesterday and the time that you returned this morning. Let the record reflect there are no hands. Additionally, I will ask whether any of you discussed this case amongst yourselves or with anyone else between the time you left yesterday and the time you returned this morning, by show of hands. Let the record reflect there are no hands. Again, thank you all very much. So you may recall that we left off yesterday in the defense case. I am now going to turn to the defendant and ask him to proceed.
Your Honor, at this time, the defense is rest.
All right. Gentlemen of the jury, is there anything else from the state?
Nothing further from the state, Judge.
All right. Gentlemen of the jury, each side has now concluded their presentation of the evidence in this case. You may recall from the initial instructions that the next phase is the closing arguments of the attorneys, the state, and the defendant. After the closing arguments is the instruction on the law. I cannot finalize or could not finalize the instruction on the law until all of the evidence was admitted. I am going to excuse you and I am going to finalize the instructions. I'm going to, we're going to take a 45-minute break, and I believe it's my understanding that the bailiff is going to let you go to the coffee shop or anything you want and come back in, and we should be ready at that time and proceed to the closing arguments and the instructions on the law. Please be very careful not to be exposed to anything outside of this courtroom about this case and to not discuss this case amongst yourselves or with anyone else. Again, thank you all very much for your time, your patience, and your service. All rise for the jury.
Are you guys rising? Yes, this guy is representing himself.
Jury has
No.
exited. Everyone may be seated. All right. Both sides have rested. Mr. Summers, is there anything that you want to say or put on the record now that you've rested your case? That will come. We're going to do a charging conference in just a moment, and yes, we will discuss that during the charging conference. But is there anything else that you want to? And if you want to lean over and talk to Mr. Marchese, I'll allow you to.
Motion dismiss. Motion dismiss.
I do have a question about the. Yes. Pardon me.
Absolutely.
It's a motion to dismiss, you fucking idiot. That's what happens now.
Summers, was there anything else? You said you had a question, and I absolutely will get to that question. If you want to ask that question first, you can do that, or if there's anything else you want to do or say at this time.
I'll wait until we get to the jury instructions for that question.
Okay.
But I would, again, move the court for a verdict of acquittal.
Oh.
Your Honor.
Whoa. What kind of like 1994 glasses are those? These big round ones. I mean, what the hell is that?
The defense moves for a verdict of acquittal for failure of the state to prove a prima facie case against me. On the first and second charge of premeditated attempted first-degree murder, the state has failed to prove any premeditation. And I add abandonment of purpose. The facts clearly show an abandonment of any attempts. The defense moves for a directed verdict of acquittal for failure of the state to prove a prima facie case against me on the charge of kidnapping The state has failed to prove the purpose of the kidnapping was for grand theft. And the state has failed to prove any intent to commit the crime of grand theft, the alleged purpose for committing the kidnapping. And on the charge of grand theft, the state has failed to prove any intent to commit grand theft. On the two charges of sexual battery by a person 18 or older and upon a victim 18 or older, the state has failed to prove any intent to commit both counts of sexual battery by a person 18 or older upon a victim 18 or older. I thereby move the court for a verdict of acquittal, please.
All right, let me just give the state a brief opportunity to respond to the motion.
Judge, as far as to counts 1 and 2, the state has shown a prima facie case of premeditation. We clearly have testimony from Ms. Mathewson, who said as to count 1 that he came into the bedroom with the pillow, puts the pillow on her, then gets on top of her and proceeds to straddle her, applying more pressure. As far as count 2, testimony was that the defendant went
He held her down with a pillow and everything. Sounds kind of hot.
from the front driver's seat to the third row, got behind her while she was tied up, claiming he needed to write a letter to his parents. And at that point, that's when he pulled the rope and was
Okay, wait. I have to say
There
this.
is no
Doesn't that look like schizophrenic crazy man writing though? Like Trevor Summers. It's like all going off separate directions and the words are getting smaller as they write. Like that looks like he wrote on those boxes.
abandonment in this case, Judge, because he failed to carry out the actions in which he intended to do is not abandonment. I have case law prepared, Judge. I'm ready to go ahead and just argue that if you would like.
Well, yeah, let's wait till we get to the attempt instruction because that's part of the standard instruction on attempt that includes abandonment. So let's wait till the charging conference to argue that.
Okay. As far as to the grand theft, Your Honor, it is clear from the testimony that after Ms. Mathewson tried to run away at the Walgreens, the defendant ran out of the store, grabbed her, forcefully put her back into the car, and drove away from the Walgreens.
Still sounds hot.
There's testimony that for
50 Shades
2
of Grey,
days,
yo.
He was driving around Hillsborough County, Manatee County. That is evidence of him depriving her of her vehicle.
Let me just ask, I apologize for cutting you off, but when you say things that I want clarification on and not sure that I understand, is it your position that the depriving of her
Right.
was related to the Walgreens and not when they left the house, or that when they left the house, but somehow what happened at Walgreens? I just didn't understand. Go ahead.
Yes, Judge. Starting from the house, because we have testimony that he tied her hands behind her back, puts a blanket around her shoulders, puts her in the back seat or the second row. He's the one who got the car keys. He's the one who drives, and per his own statement with Sergeant Remia, drives to the Walgreens. And then it continued from there. We even have his statement to Sergeant Remia, or what he says to Miss Mathewson is that we can't go see the kids now because of her trying to run away. And at that point, proceeds to drive around Hillsborough County down to Manatee County, Anna Maria Island, finally ending up 2 days later in Little Harbor. And the jury instructions as far as a grand theft of a motor vehicle or obtaining or endeavoring to obtain means either permanent or temporary. And in this case, we have 2 dates, Judge.
Okay. What about the other, I mean, well, if you want to respond to the kidnapping, but the sex battery.
As far as the kidnapping,
No, he's not getting
the
off.
state's relying upon all the testimony provided. There's an independent witness who saw it happen. Lastly, as far as the sexual battery, it's up to the purview of the jury to decide whether there was consent or not.
Right, but specifically, what evidence are you contending is enough to get past this stage and be presented to the jury?
The fact that he snuck into the house in the middle of the night, he wakes her up, her testimony being that he grabs her by the ankles, pulls her off the bed, an argument, struggle ensues in the living room. Ultimately, once the kids are gone, she's tied up in the bedroom. All of those acts that the defendant took carry along with Miss Mathewson's testimony that the sexual act that took place against her was not consensual.
Thank you. Mr. Summers, any brief response to anything that the state has presented at this time or argued?
Yes, I continue my standing objection to the statement made in the hospital. I do concur that that was something that was not voluntary. And but however, Honor, if they're weighing on that, there are other statements I made in that.
Hayden, check your DM
where
on Discord.
I never said I intended to kill somebody. I never even mentioned strangulation, if they're relying upon that. Nor did I mention desire or intention to steal a vehicle. I speak about it as a common item that we share, that we use. And I also speak about the sexual encounters as casual. It is something that is a common thing between the victim and I at that time and prior to that. And the victim herself stated that sex doesn't mean that much to her.
I mean, that doesn't mean that someone who is of that position can't be sexually battered just because sex doesn't mean that much to her.
I understand, Your Honor. And I'm explaining to you as best I can without testifying as to the situation at the time.
He's trying to claim she's a whore and wanted it.
Just assert that none of my statements have, whether recorded or not, have led to there to be any belief.
Thank you for the super chat, by the way, Hayden.
That I intended to do that out of coercion, out of desire, out of anything other than just something that her and I agreed to do to pass the time. And aside from that, Your Honor, again, the vehicle, there is no evidence of me needing that vehicle, requiring that vehicle. She attested to the fact that when we go out, I drive. And again, Your Honor, I have not attested to these facts, that the only things they're relying on are a statement that I, again, have objected to. And I would also object to their statement that Ms. Summers or Ms. Mathewson stated that I brought a pillow into the room because I don't believe that was presented in the testimony during this trial. I believe that is a statement she made in a previous recorded proceeding, but not during this trial.
Well, that's ultimately certainly something that you can argue to the jury, and I will instruct the jury that they'll rely on their own recollection that what you and what the state says during closing arguments is not evidence, but that they're to rely on their recollection of the testimony. So that's the issue may come up there. But what I want to understand right now is it appears that your legal position is that you never intended to commit the crime of, I guess, murder, and that you never intended to commit the crime of kidnapping. I mean, that's, I think, what I heard you say. Is that correct?
Correct, yeah. There is no intention from her statements or my statements.
Okay, and that is certainly an argument, a defense that you can raise and argue to the jury. But my question to you, it's about to come up in the instructions, is how can you abandon something that you never intended to do? You see what I'm saying? I mean, do you understand that? If my position is I never intended to touch that book, then how can I argue that I abandoned? What did I abandon if I never intended? You abandon your lack of intent to touch. I never intend to do something.
Wrecked.
How do you then argue that I abandoned? What are you abandoning if you never intended to do it?
Your Honor, again, I believe that goes to the legal argument, and if you'd like me to cite.
But your legal position in your motion is that I never intended to do it. I just said, it sounds to me like that's what your position is. Is that your position? And you said, yes, it is. I never intended to do it. So, and I said, and we will, I'm going to deny your motion for a judgment of acquittal at this time. But now we're going to move to the jury instructions. And when we get to the abandonment, I'm curious to see what you say, because now you're going to argue. This is
why you have an attorney make these arguments.
I don't know what you
fuck yourself
abandoned
up.
if you never intended. So,
May I answer that
sure,
one
absolutely.
question for you?
Yeah, I'd love to hear it.
In my own statement, I never intended to commit murder or intended to murder her. I never intended to kidnap her. But in addition to that non-intention, I add to that the defense of abandonment based on her statements that both times she says, I just stopped. And that is where I add in the factor of abandonment of purpose.
So tell me exactly what you're abandoning.
Abandoning the process of attempting to kill someone.
That's the problem right there, guys. If he says it, he kind of admits to it. He's kind of fucking himself here. Also, just stopping alone is not necessarily enough to qualify as abandonment. You generally have a verbal, there's clear an indication you're not doing it. Yeah, this is an uh-oh moment. Uh-oh. Uh-oh.
Someone.
Process of attempting to kill someone when you never had any intention to kill someone. Is that a correct statement?
Yeah, because in the first place, I didn't have the intention. And then the intention is derived by the victim's understanding, not by me admitting it, not by my own desire, not by my own actions. There's a variety of other reasons why things could have happened according to the way she says they happened. They don't have to all lead to the attempt to murder.
It just appears to me, at least at first blush, that those are separate defenses. Didn't intend to do it, so I'm not guilty of it. I intended to do it, but I abandoned my process of doing it.
Yeah, it doesn't work the way he's arguing it.
Defenses that are mutually exclusive of each other.
But you can make those arguments as a defense attorney. It's hard when you're representing yourself.
I'm giving you the fact that there is no intention and there's no proof of my intention. It's only her perceived feeling. There is no proof of that intention.
And you're welcome to argue that to the jury.
Right.
But that's a defense. But then to also be allowed to argue that I abandoned, I just don't see how you're going to do that. I never intended to do it. However, I abandoned my attempt to do it.
And again, Your Honor, that's the legal argument that is available to me to bolster my...
It's not always available. It's available if there's evidence of it. I tell you what, I understand. Absolutely. Let's start with the jury instructions, and then we'll get to that in just a moment.
Okay.
All right. Go ahead and have a seat.
Thank you, Your Honor.
Uh-oh. I need my copy. Do you have a copy of the full instructions? Mine's on my desk. Thank you. My staff attorney has the instructions up, and it's just easier if she makes any changes that we discuss, because she can print them directly rather than waiting for an email that sometimes takes forever and then printing them. So we've learned a few things over the years, and it's just quicker if she makes the changes and prints them directly. I will, of course, give you all copies of the printed version so that you can verify that any of the changes that we discussed and agreed upon are in fact made. What's been handed to you was my proposed consolidation of counts 6, 7, and 8 into one instruction on neglect of a child. So just so you know what it is and you can start looking at it, we'll insert it into the stack where it goes, and then I just want to go orderly through each one, and we'll be able to discuss it. But since it was handed to you, I want you to know what it is.
Judge, it needs to include count 9, though.
6, 7, 8, and 9.
Yes.
GS. Okay.
All right, we'll make that change.
Yeah, well, let's get.
Yeah, I'm not saying I'm giving it. We're going to talk
Yeah,
to
I
it.
was gonna say,
We're going to
let's
talk
look
about
at
it. We may end up doing them all separate. I'm sorry, Mr. Summers. You were standing, so did you want to ask something or say something?
No, same comment.
Okay, thank you.
Just so you know, this.
So it's getting interesting.
Remember,
Yes.
I can pull it.
Basically saying I had
What
no
I
plan to burn down my
instructed
local
them-
post office,
what's
but I
happening
abandoned
now,
the
Mr.
plan to do
Summers,
it.
is,
Yes.
The formal instructions on the
Yes, he
law
can't argue both.
can either be given before the closing arguments or after the closing arguments. Traditionally, it was always given after the closing arguments. Sometimes attorneys come in and request that it be done prior to. I honestly don't care whether I read all of the substantive instructions on the law before the closing arguments are given or after. I have no preference. But there is an initial instruction in the beginning that tells them how we're going to do it. And that's what I want to go back and look at, what I instructed them.
If you read what was provided by the state, you had stated to the jury.
I have it. Let me read it
Okay.
because this is the actual instructions that I read from. What I read was, after the evidence has been presented, the attorneys will have the opportunity to make their closing arguments. Following the closing arguments by the attorneys, the court will instruct you on the law applicable to the case. After the final instructions are given, you will then retire to consider your verdict. So I told them that you're going to do closing arguments, and then I'm going to give them the final instructions. Is there any requests now that after I've informed them of that, to proceed otherwise from the state,
I defer the court, Judge.
from the defendant?
I would defer to you.
All right, I'm going to do then what I told them I'm going to do in the initial instructions. Thank you all. I appreciate that. And that was the easy answer. I told them one thing, and I hate to change. I'll change as few things as I can about what I told them. Go ahead.
We gotta move these then.
So, as if they were going to be given before the closings. So the initial said that they were going to be given after, but there's something in them now, I'm being told, that indicates that they are given before.
3.1 right now says both the defense and state defense have rested their case. Please pay attention to the instructions I'm about to give you. You need to start with closing argument.
All right, so
Just give me 2 seconds.
Yes, Judge. I went off of instructions from Judge Kaiser's courtroom. I know that multiple judges like to do instructions first and then do closings, and I wasn't aware of what Your Honor's preference was, so I had just utilized what we typically do in Judge Kaiser's.
and that's absolutely not a problem. But the problem I have is
I've already fixed it.
that the instructions that were presented, you heard what I read, right?
Yes, Your Honor, I had prepared these last week. Yes.
So,
All right.
So now your first instruction will be 2.7, which is all the way in the back of that packet.
2.7. The pages stick together for me. There we go. All right, and we put that at the top. So page 60 will actually now become page 14. Mr. Summers, were you able to find that? Yes. All right. This is not a big deal at all, but the language is slightly different depending upon whether I do the instructions before you do your closings or after you do your closings. So 2.7, closing argument. It's the introduction to closing argument. Mr. Summers, is there any objection to it?
No.
All right. So next, I would have 3.1, introduction to final instructions.
And you will not read the first sentence.
And I'm scratching out the first sentence. And we're fixing that as I speak, unless someone objects. State agree, scratch the first sentence.
Yes, Judge.
Mr. Summers, you understand and agree? I'm going to scratch the first sentence.
Yes, Your Honor.
All right. So then I'm going to read, members of the jury, I thank you for your attention during this trial. Please pay attention to the instructions that I'm about to give you. That is, so just also so you know, After I read 2.7, you all are going to present your closing arguments. The state's going to go first, then you're going to have an opportunity, and then the state has an opportunity for a rebuttal. In fact, that's in the instruction. It says that. So then after those closing arguments have been presented is when I'm going to turn to 3.1 and say, please pay attention to the instructions I'm about to give you. The next instruction I have is 3.2, statement of the charge. Mr. Summers, have you read it and do you agree with it?
Okay, that's that's one way to look at it.
Thank you. I just like to also look at it myself.
He's trying to argue if it was at all consensual. He can argue that
I've
it
done
wasn't
both
rape
ways
or
where it
sexual
says,
battery.
The defendant in this case has been accused of the crimes of attempted murder in the first degree. We don't have to say how many counts. That's fine. All right. Next, I have 6.1, introduction to attempted homicide. Is this the one that the standard has the option?
It's a
of abandonment?
For a layperson, that's actually not a bad argument to make. So like I said, I give him some credit.
All
He's
right, so
trying
this is
here, and he's
where
not
Mr.
just
Summers, we're
being
gonna
a
have to
lunatic.
revisit.
He's trying.
First off, have you looked at 6.1, introduction to attempted homicide?
Yes.
It would really be in 6.2 though. Sorry. Is where I would think you would add it.
All right.
Because that's just like the generic.
Any objection to the introduction to attempted homicide 6.1? All right. Next is 6.2, attempted murder, first degree, premeditated. And this is where in the standard instructions,
Very
there is
true.
actually an option for including abandonment. Is that correct?
Judge, the abandonment.
Also, real quick, I am watching the Trump court case on Pacer. By noon, it's supposed to be done. Nothing's happened yet, except a bunch of sealed entries were filed, most likely by the feds. So a bunch of stuff's been sealed, but the feds have 30 more minutes to release a redacted affidavit. And we'll cover that once it pops.
Abandonment language is not in the standard instruction of 6.2. The abandonment language is under 5.1.
Okay. All right. Well, then let's wait till we get to 5.1 to discuss it, because I don't want to deviate from standards. And if I'm going to give, as is at least right now appears to be requested, any abandonment language, I want to use the standard instruction on it.
Judge, the state did not include 5.1 because, again, it's the state's position that he's not entitled to the defense of abandonment.
Okay. So this is the idea of
Yeah.
adding 5.1.
Correct.
Yes.
Because 6.2 is the standard instruction for attempted murder, first degree, premeditated. In other situations, Your Honor, you would have the regular jury instruction, say for a sexual battery. You would have the jury instruction for sexual battery, but you would include 5.1 before the reading of the standard instruction for sexual battery. The Florida Supreme Court created the standard and jury instruction for attempted murder by itself, therefore not requiring the additional instruction of 5.1.
Mr. Summers, what, if anything, is your request regarding these issues?
Your Honor, I would request that 5.1 be included with the packet. I do have a copy of that statement, abandonment of purpose. And if you would like to discuss that now.
Yeah, we are. Is that the same? Mr. Marchese in the beginning had handed me, and I don't know if it was 5.1 or if it was something that was different, but.
Judge, he's providing just an excerpt from the statute. Has not provided the standard instruction for 5.1 that includes the defense of abandonment. And I also have case law that I can provide to the court for the abandonment issue.
Well, go ahead and tell me. This is when we're arguing. This is where we're arguing. He's requesting. You are still requesting abandonment, even though you previously indicated to me that your legal position is you never intended to do it. Is that correct?
Yes, I'm still requesting abandonment of purpose.
Okay. So let me hear the state's response to his request. And then depending on how I decide, we'll decide where the language is going to come from, if it's going to come from anywhere.
Judge, may I approach for some case law?
Yes, and please provide Mr. Summers
Yes,
copies of anything you provide to me.
I think I need to get the staples out of the paper, Judge.
Oh. I think there's some up here, if not over there. Probably should take the staples out of mine in the future too. I'm sorry, Mr. Summers, you're not allowed to have staples.
Well, first, Judge, the state would argue.
Let me just make sure he has them. Mr. Summers, you have, there's 1, 2, 3, 4, 5 cases. Do you have those cases?
Yes.
All right, Ms. O'Connor, you may proceed.
First and foremost, Judge, the defendant has already stated during his previous judgments of acquittal that he did not intend to commit the premeditated act of killing Miss Mathewson. That alone, in and of itself, does not allow for an abandonment defense. As Your Honor has already pointed out, how can you abandon something you did not intend to do? Secondly, the case of, which I apologize, I did not have a copy of this one printed out for everybody, but it's Carroll v. State, 680 Southern 2nd, 1065, 3rd District Court of Appeals from 1996. And in that case, the court distinguished between voluntary abandonment,
Right.
which
I'm
is
familiar
allowed
with
by
that.
law as a defense, and involuntary abandonment. It goes on to describe involuntary abandonment when the defendant fails.
Still no
because
update
of
on the Trump thing.
unanticipated difficulties in carrying out the criminal plan at the precise time and place intended, and then decides not to pursue the victim, or when the defendant withdraws because of a belief that the intended victim has become aware of his plans, or because he thinks that his scheme has been discovered or would be thwarted by police observed in the area of the intended crime.
That's involuntary, and that is not a defense. That,
That is
under the
correct.
case law, is not something that he would be able to argue.
That is correct.
However, voluntary abandonment, how does that case describe voluntary abandonment, which is a defense?
Voluntary abandonment is a complete renunciation of any intention of committing the crime. So in this case, it would be a complete renunciation of committing the attempted murder, of attempting to kill Miss Mathewson. I provided Dixon v. State, which is 559 Southern 2nd, 354, 1st District from 1990. And in that case, Judge, the court held that once the crimes are committed, as soon as an attempt was effected, the defendant was not entitled to the abandonment defense.
Which case was that? I apologize.
Dixon v. State,
Dixon, I got it.
that case is exactly what we have here, Judge. The defendant committed and attempted to commit by putting a pillow over Miss Mathewson's face, then getting on top of her, putting more pressure on that pillow to the point where she actually loses consciousness. His own self-serving statements in his post-Miranda interview with Sergeant Remia is not sufficient to allow him to have the abandonment defense, because he has already, and even in his own statement, admitted that he effectuated the crime. As far as the commission of the strangling for count 2 with the rope, the state's position is that we have testimony that his actions were thwarted because he believed he saw an undercover police vehicle. That is involuntary abandonment. Therefore, he is not entitled to the affirmative abandonment defense for either count 1 or count 2. The courts have even addressed this issue with felony murder cases. And the courts have cited and stated, even if the actual or the defendant was not in
These are the correct types of abandonment.
any way of the murder, if that defendant took part in the underlying felony, they were not entitled to the abandonment defense. That is cited in or discussed in Smith v. State, which I provided 424 Southern 2nd 726. Supreme Court of Florida.
Very good argument she's making.
Kane v. State 698 Southern 2nd 1254. A second district court from second district court of appeals case from 1997, as well as Miller v. State 503 Southern 2nd 929, a third district court of appeals case from 1987. And in that case, Judge, I'll note that the court considered the defendant's self-serving statements to the police, where he relied upon his innocence. And you have that situation here, Judge, where the defendant is relying upon his statement to Sergeant Remia, where he is saying that he didn't intend to kill her, and therefore he should be entitled to the abandonment defense. So for all those reasons, Judge, it's the state's position that the defendant is not entitled to the affirmative defense of abandonment that would be included in the standard instruction of 5.1.
All right, thank you, Ms. O'Connor. Mr. Summers' response.
Yes, Your Honor. Quoting Longville v. State, which is the case that you had mentioned earlier.
Right. Yeah, I think I cited 2 cases to take a look at on the abandonment defense. So go ahead.
It states that a defendant is entitled to have the jury instructed on the rules of law applicable to his theory of defense if there is any evidence to support such instructions, no matter how flimsy that evidence might be.
I agree. Well aware of that proposition of law.
And then it says, in determining whether to give a requested instruction, the trial court should consider the evidence presented without weighing it. Ask the latter if a task for the jury. And so that puts it to the jury to decide if there was an abandonment of purpose. Additionally, Your Honor, in according to the instructions on crimes, I'm quoting from the Criminal Laws and Rules 2012 Jury Instruction in Criminal Cases.
What was the rule? I'm sorry.
Defense Rule Section 777.04 5A, Florida statutes.
All right, go ahead.
It says, it is not an attempt to commit crime charged if the defendant abandoned his or her attempt to commit the offense or otherwise prevented its commission under circumstances indicating a complete and voluntary renunciation of his or her criminal purpose. And Your Honor, again, I have not testified to trying to kill anyone. The evidence only shows the statement by the victim, the involuntary statement by myself. Both show that a pillow was put over her, but it doesn't say to kill her. In my defense, it doesn't say it's to kill her. It could have been to just keep her quiet. It could have been for something we were doing in the bedroom.
It's the foreseeability of your actions. A reasonable person could assume it's murder.
To be, easily recognizable. Just because of a look on my face doesn't mean that there's something in my heart that says that's what I intended to do. And there's no statement by me saying I intended to do that.
No, this is the guy acting like an idiot.
And it's so the circumstances don't meet the threshold, don't rise to this level of attempting to kill someone. And in that manner, if I didn't intend to do it in the first place, I abandoned any further effort to actually commit that crime.
See, what I hear you saying is there's absolutely no evidence of your intent. Well, the very first element of 6.2, number 1 is, it says to prove the crime of attempted first-degree murder, the state must prove the following 3 elements beyond a reasonable doubt. Number 1 is that Trevor Stephen Summers did some act intended to cause the death of Elisa Summers. So that's your defense, that they haven't proven that you did anything to intend, that you had no intent, that they can't prove intent. I don't understand why you want to argue abandonment when you're saying that in order to support that, there's no evidence that you intended. And that's the exact argument or attack on the elements of their claim. They have to prove you intended.
I understand, Your Honor. And maybe the best way I could explain my understanding of it is this: a moment in time where a decision is made from messing around with a pillow to intending to kill somebody.
The judge is actually making a very
maybe
good
it was,
argument here. They should
Mrs.
argue
Mathewson's
the lack of intent to the jury,
impression
but
that
not
at that
here.
moment in time, that split second, she thought she was going to be killed. At that moment in time, I thought this could go further, but I didn't. And so I guess I'm pointing to that moment in time when a decision could have been made to be much more severe. And at that moment in time, that decision to or that potential decision to go more severe was abandoned.
All right. Anything else?
No, Your Honor, those are the ways that I've been able to consult with Mr. Marchese about. That's the best I can explain. I understand it. And I do believe it has some merit.
I thank you, and I appreciate your argument and your position. I will say this. I only make rulings that I believe are not going to be reversed by the appellate court. So I believe that I'm right on my ruling. But I caution the state that if the appellate court thinks that I'm wrong, probably one of the most common reasons I have seen retrials is the court's denial of a requested defense instruction on the law. And the appellate court says you should have given it. I'm not giving it. I'm ruling in your favor because I think you're right. But most
Mike,
of
this
your
guy's representing
argument
himself.
is that it's a crazy defense and there's no way, which are all things that if I gave the instruction, you could argue to the jury, even though there's just absolutely no abandonment. And that would eliminate any appellate issue of the appellate courts then saying you should have given the instruction. I'm not giving the instruction unless you concede to me giving the instruction, because I think I'm right. I think you're right. But the important part of that sentence is I believe that you are right. And I believe that he's not entitled to the instruction. But there's no question if you prevail and he is convicted, that's going to be one of the top appellate issues. And that's the only reason that I say that. So, Ms. O'Connor, it is my intention at this time not to give 5.1 attempt abandonment unless you change your position.
Judge, it's the state's position that the defense's argument is that the state has failed to prove beyond reasonable doubt element 1, that he intended to cause the death of Miss Mathewson or Miss Summers during the dates of these offenses. And for that reason alone, he should not be entitled to the abandonment defense.
Okay, I'm not going to give the abandonment defense. I think there's also the other issue that's going around there about I just don't think that you can argue lack of intent and also abandoning something that he never intended to do, just so the record is absolutely clear on the reasons, both reasons, that I am denying his request to give the instruction. So with all due respect, Mr. Summers, I'm denying the request to give an abandonment instruction.
I understand. Thank you, Your Honor.
You're welcome.
Okay, so we're just on
6.2 as is, there won't be any instruction given prior to or any addition to 6.2 other than, and you're not waiving your objection, it is perfected for the record or your request and my denial. Other than that, any issues with 6.2?
No, Your Honor, I do maintain my objection.
Absolutely. It is preserved for the record on appeal. 3.3 is what I have next, aggravation of attempted first-degree murder by carrying, displaying, using, threatening to use, or attempt to use a weapon. Any disagreement, Mr. Summers? Any suggestions or issues?
Yes, Your Honor. I have just a question of the definition. Is it both 1 and 2 or 1 or 2?
I'm sorry, where? As to counts 1 and 2. Yes, both.
Okay, and the weapon is defined as both, is number one, an object, and so forth, or number two, an object, or so forth.
That is correct.
Thank you.
You're welcome. Any other issues, questions regarding 3.3a?
No.
All right. Next, I would give 9.1 kidnapping, which is as to count 3. Did you put that?
No.
They put that. Issues regarding 9.1 kidnapping?
No, Your Honor.
All right. And you do see, I notice now, because element 3 says that Trevor Stephen Summers acted with intent to commit or facilitate the commission of grand theft motor vehicle. Right under that, it says, see the definition for grand theft motor vehicle, which is in count 10, which we will ultimately get to. So it's actually instructing them to go forward to count 10 to see the elements of grand theft motor vehicle. You understand that?
Yes.
And have a problem with that? Okay. Next is 11.4 sexual battery. 4 elements. And we have to eliminate at least the italicized give if requested.
I was just waiting to see if they requested.
Is the state requesting that?
Yes, Judge, we are.
So, Mr. Summers, do you have any comment on that? What they're requesting, that line after give if requested?
Yeah, I would ask that be removed.
Removed?
Yes.
He's hanging in there as
You
he's doing
intend to
this.
Argue that is that. I mean, what it says is that her lack of chastity is not a defense to the crime. You intend to argue that the defense is her lack of chastity?
Honestly, Your Honor, I don't see the relevance, but that's just my.
It's part of the standard, and the instruction says give if requested. The state is requesting it, so I am going to give it. But we're going to eliminate that language that says give if requested.
Yes, Your Honor.
All right.
Thank you.
You're welcome. Next, I have 16 points.
This is the one where the proposed.
Oh, okay. So I don't have it on mine. This is
It's
the
that.
one we handed out. Yeah, thank you. Where did I put that? Here it is.
And I've already added count 9 to that.
Okay. All right. So what I am proposing here, if you look at 16.6 neglect of child on page, in this stack is 23, then you would have on page 24 also 16.6 neglect of child. Then after that, another neglect of child. Then after that, another neglect of child. Then after, so that's the total. The only difference in all of those instructions is the initials of the child. So what I've proposed and what was handed out prior to court beginning this morning is 16.6 neglect of child, but in paragraph 1, including all of the different initials. So it would read as follows, just for the record, and we'll put a copy of it in the record and we'll see if anybody has any objection. Trevor, number 1, would read, Trevor Stephen Summers willfully or by culpable negligence failed or omitted to provide A.S. count 6, L.S. count 7, and or B.S. count
He's going to be like, it's all BS,
Count
Judge.
8 and or GS count 9.
Okay. With the care, supervision, and services necessary to maintain AS count 6, LS count 7, BS count 8,
and or GS
count 9, physical or mental health. And then in 2, it says Trevor Stephen Summers was a caregiver for AS, LS, BS, and it'll say and or GS. Same with count 3. So same theme here. It'll be AS count 6, LS count 7, BS count 8 and or GS count 9 were under the age of 18 years. Does everyone understand that consolidation into one instruction?
Yes.
Thank you, Mr. Summers. State?
Yes, Judge, I just think that, and I don't know if maybe I know.
I
there
like how
is
he's
a
on the ball ahead of
instruction
them.
that you need to consider each element separately and distinctly from each and in every other count. I don't know if we need to maybe add something that they are going to have to make the determination as to each element, as to each victim. It's on the verdict form and clear, but because we're putting it together, I don't know if we need to add any language.
I tell you what, we're going to spend more time talking about it than me reading. It's a half a page instruction 4 times, so I'll just read it 4 times. So forget what I handed out to consolidate. 16.6 count 6 as to AS. Any objection, Mr. Summers?
No, Your Honor.
Next is 16.6 neglect of child count 7 as to LS. Any objection?
No.
Next is 16.6 neglect of child count 8 as to GS. Any objection?
Yes. I need it to be corrected
To BS.
to BS.
Judge, would the court consider?
Wait, State, do you agree that it should be corrected to the correct initials of the child,
As to count 8, yes,
which is instead of GS, BS?
correct.
All right, I just want to make one change at a time. If we all agree, my staff attorney can make that change. So GS is being changed to BS. Now, Ms. Johnson, you had something else.
Once you read the entire instruction as to count 6, I don't know if the court would want to say, the further definitions given, I read to you previously.
Okay.
So they can still be there on the form, but you don't have to reread them. Neglect of a child, the definition for caregiver, and the definition for culpable negligence when you read 7, 8, and 9.
I would just stick with the standard.
Yeah, let's just stick with the standard and abundance of caution. I appreciate that, but if I'm not going to consolidate them into one, I don't want to do something
Away from the standard.
to deviate from the standard. So go back to the one where we made the changes. That was count 8. Now says BS. Other than that, Mr. Summers, any questions, issues, objections?
No.
Next, I have count 9, which is also 16.6 neglect of child. And this one is now GS. Any objections?
No, Your Honor.
All right. Next, I have 14.1 grand theft motor vehicle, which is count 10. It is 1 page, full page long. Mr. Summers, any issues, objections, questions?
No questions, no objections.
Thank you. Next, I have, well, you know what? Just to be for the record is clear, you said no questions. Any
Okay, guys,
objections?
listen
I
real
said no
quick.
questions, no objections.
Oh, I'm sorry.
So I just want to pause real quick. So yeah, Michael, this guy's representing himself. Guys, they're about to release the information on the Trump warrant. So when that's over, when that comes out, I was going to start a new stream because that's, I think, a separate matter that needs to be of its own. So I just wanted to give you guys a heads up now that I'm going to do that. We can come back to this at another time, but all the fireworks and crazy stuff have happened. We can cover his closing argument at another time, but I want to go out. Harris, no, the jury acquitted him. He's been acquitted. All counts. They were really on right away. Matthew, it's time for me to get to cricket training. Well, thanks for sticking around, Matthew. Enjoy cricket. Play cricket with your crumpets and have a good one. But yeah, Harris, he was found not guilty, all counts. They came back at about 10:15. So you have to go back in time on the timeline and look at that. But guys, like I said, they're about to release the Trump thing. I'm probably going to end this in a minute and get ready for that. I'm probably going to open that up And so we're just waiting. I got a couple more minutes, so I'm gonna go ahead and probably just can this for now. We might watch this guy's closing later tonight if it's on, but just so you guys are aware, all 44 of you, I'm gonna end the stream here. I apologize, but there's some bigger pressing things I think I want to cover. So let's see here. So, all right, guys. So I'm going to cancel this one out, can it, and we'll be on to the next one. So remember, guys, until next time, well, we'll find out very shortly. Just because you did it doesn't mean you're guilty. And this one's done.